creditor rights, responsibilities, and remedies. And I did want to mention one of the things that confuses people is artisans' liens. I'm going to clarify that in a minute. We've already talked about guarantors and sureties. We're going to revisit that subject with regard to our current chapter topic on collecting judgments and so forth. I did want to mention that I personally checked this link, and this link did not work earlier today. So I think it's like a lot of things loaded to the internet. Sometimes they're moved, or sometimes they're just taken away. So in any event, let's talk about this for a minute. One of the things that happens, and I think we mentioned this in the chapter module 3, the contracts module, is we talked about performance bonds being required in contracts. Generally speaking, for public sector contracts, you do need to have a performance bond in place. And what this is, it's an insurance policy that the construction company buys that's in favor of the public entity that is contracting for the work. So the reason for this is if a construction company starts a project and does not complete it, then the public entity goes to the performance bond company and says, hey, you need to pay a subsequent construction contractor to finish the job for the first one that didn't finish the job. To use a very sad example, some of you may know, I think it happened on Tuesday while we were actually conducting our class, there's a new building being constructed on I-10 just inside the Beltway, the Sam Houston toll road. And inside the building, by the way, I drove by this building just earlier today, is a concrete staircase collapsed. And this is a very odd deal. 3 construction workers were killed in the collapse. And I'm really not sure what was going on, because it seems unlikely there would have been 3 construction workers in that position at the same time. So perhaps they were actually trying to do some type of repair or something together, and then the thing just simply collapsed. But in any event, if that happened and perhaps the feds came in, the Occupational Safety and Health Administration, and shut down the project for that contractor, that could be a situation where the performance bond would be called into question to say, hey, you need to come in and finish this project, since First Construction Company won't be able to do it. So that's an example of that. Now, in that particular case, I don't know if there's a performance bond or not, because it's a private sector project, and private sector projects may or may not have a performance bond. Generally do not. Again, mostly it's in the public sector. Now, this is one of the more confusing aspects of this chapter. We've already touched on this in an earlier chapter, but this is something that people oftentimes refer to as a mechanic's lien. Let me explain why. An artisan's lien is a security interest in personal property in favor of one who has performed services on that personal property. Classic example, you take your car to the car shop, and they do repairs on your car. They then have an artisan's lien on the car, even though they're a mechanic. So for some people, they automatically use the term mechanic's lien. We're going to correct that in a minute and show you what's the correct terminology. So please be careful when you're doing quizzes or the midterm, or this would be on quiz 3 in the final, is to keep track of this is an artisan's lien for a mechanic. And one of the examples that we use here is, so the mechanic does work on your car. Maybe the mechanic told you that it was going to be $1,000, but when you go to pick the car up, it's $1,500, and you can't get your car and your car keys unless you give the mechanic the $1,500. So you write a check instead of using your credit card. As soon as you get home in your car, you call your bank and put in a stop payment. A couple days later, the mechanic realizes that you've stopped that check. At that moment, the mechanic has a right to enforce their artisan's lien, send a tow truck out to pick up your car until they get good funds to replace that. Plus, they're going to charge you probably a couple $100 extra for having to send out a tow truck to pick up the car. Now, there is a special rule on this, and sometimes you do see in some television shows and other settings on the evening news that there can be violence associated with this. So tow truck drivers are not allowed to breach the peace. They are not allowed to enter your property to get to your car. So most of the time, the car is seized if you parked it out on the street out in front of your house or in the neighborhood, or perhaps at a nearby shopping center. And in fact, there's services that publish lists of cars by license plate number, and people can actually get a bounty for calling up a particular number and saying, hey, I saw this particular car sitting in a parking lot over near the Galleria, and if the tow truck goes over and the car is there and they grab the car, then they owe you a few dollars as being the tipster on that. So it's an interesting system. It's amazing how many people actually are behind on their car notes or owe on mechanic services and so forth. So keep in mind the term artisan's lien. Now, one of the ways that you can terminate the lien is to simply give up the car in question that we were just talking about. Now, one of the ways to cover an artisan's lien may be to leave the property with the artisan or the mechanic until it has been, until you're able to pay for it. So say that you have an antique that is in dire need of restoration. So you take the antique to the company, to a particular service provider, and you say, we need you to take this classic antique furniture piece apart, refinish it, put it back together. And so they do that over a couple-week period, and they say that's going to be $1,000. You don't have $1,000, and they don't take credit cards. So you may say, well, look, I'm going to get the money together, but please do not sell my piece of furniture. It's important to me. I am getting the money. But in the meantime, you can keep the item so you're not at risk of losing any money because I'm out getting the money. In the meantime, you haven't given up the item. So that's something to think about. And at the bottom of the slide, they mention a lot of information on one slide here on artisan's liens. You may want to consider adding this to your super slide set to study for exams and so forth. But it says notice of lien is recorded. This is classically on automobiles and other large pieces of equipment that have independent titles to them, so that if you want to know if somebody's selling you their car and it's got clear title, is on the title, the original title from DMV, it may say Bank of America or the local credit union or whatever in the lien box on the copy of the title. So one of the important things to do is to make sure you're getting the current copy of the title, not a previous one, because perhaps the person paid the car off, got a clear title, but then refinanced the car. And therefore, there's now a lien on it, but they still have a copy of their old title. Most cases, they're not able to do that because they have to surrender the old title to get a new title. So something to keep in mind there to watch out for. Generally speaking, a security for creditor is without involving interest in the party. And this is somebody's promise to take care of business. Now, we're not going to spend a lot of time on this today because we've already talked about guarantors and sureties. Now, this is slide 6 of chapter 29. This is a very useful summary of terminology. Again, we've already covered, I think, all of these terms previously in the course, but you still might want to flag this slide. The deadbeat or the principal debtor is also called the obligor. That's how that's pronounced. The creditor or the obligee. The surety is primarily liable for the principal's performance. Guarantor comes in behind the fact after the principal has not performed. And in guarantor agreements, you have two. A guarantor says, I'm good for anything that this person does. And this is what we call sometimes the rich uncle general guarantor, where you've got kind of a guardian angel, and that person stands up for you and says, whatever little Bobby does, we're going to take care of them so you don't have to worry about doing business with them. On the other hand, most of us are involved with special guarantor arrangements. So you may say you have a minor son who wants to buy a vehicle. He's working part-time. And so you co-sign on the car loan, but the only loan that you're on is that specific car loan. You're not a general guarantor. And then, again, part of the situation, Flying J, of course, is a business that some of us may know in the greater Houston area. So one of the contrasts that we come into is indemnity versus suretyship. The assurance of performance is made to a party who is promising to do an act or pay a debt, and the indemnity provides security to the principal debtor. This is a situation where somebody says, if you are in a tight situation, we'll back you up, but we're really not planning to be involved in this unless something really blows up. A suretyship is a more active involvement, and that provides security to the creditors. Again, the indemnity provides security to the debtors. Now, one of the things is you say, well, who would be a surety without compensation? And the answer is there's a lot of people out there, because many times people are backed up by their family or by certain business relationships and things like that. A good example of that is you have a startup business. We're going to talk about business organizations soon. And remember, one of the things you want a corporation or an LLC to protect you from claims against the business. Here's the problem. When you have a new business, you are in a situation where the business has no credit. So you may get a loan to your business, but you're going to have to personally guarantee that loan in order for the bank to give that loan to your business. So you are acting in those cases as an uncompensated surety technically, but of course you expect to be compensated because you're hoping the business will utilize that bank loan and be very successful, make lots of money for you down the road. But that's one of many examples of an uncompensated surety. Now, compensated surety is the example I used a few minutes ago in the construction industry, which is a performance bond. Also, a fidelity bond is a situation where you may have somebody who's in a position where they handle a great deal of money. So you purchase a fidelity bond that says if the person you trust with your money rips you off, then you can get that money back through the fidelity bond. So that's how those two bonds operate. Then it says suretyship agreements are usually by express written contract. Folks, what's wrong with this picture? It's a stupid statement. Why? Because as we learned in the contracts module, we covered something called the statute of frauds. If you are standing in for the debt of another, it must be in writing under the statute of frauds. So again, I apologize because these are stock slides that come with the textbook, but sometimes the slides don't make a lot of sense. You say, well, Dr. Shine, how did that happen? Somebody's smart enough to write this good textbook. Well, the reality is that most professors do not write their own test banks, and they do not write their own teaching slides. A lot of times graduate students working for the professor do these things, and they may not understand the topics as well as the rest of us do. Now, this is a very interesting situation. The WRS case talks about the modification of a agreement where there's a surety involved. And I was involved in a case that is very close to this several years ago, and I'll explain what happened. We have a fellow who had a franchise business, and he was leasing a commercial space from a big company. So the space wasn't particularly fancy, but it was part of a huge corporation that controls many thousands and thousands of square feet of office and commercial space in any event. So he did not have enough credit when he bought the franchise to take over the lease. So the party that had the lease and sold him the franchise said, we will stand in as a guarantor. And they did. The landlord went a little further than that and said, I still want more security than that. So a second guarantor guaranteed the payment of the lease for the new franchise. So slightly different legal relationship, but that ended up with two sureties, two guarantors on the lease. And then what happened is, of course, the first 10 years went well, and the person who was doing the franchise, the new owner, extended the franchise from year 10 to year 15. And that was the end of the good times. Unfortunately, 2 years after extending the lease from year 10 to year 15, the franchisee went under. So what happened is that he was judgment proof. He's gone. He's out of the deal. The landlord wasn't unhappy because they had two sureties and they sued both of them and said, hey, this guy's got 2.5 years left on his lease. We want $60,000 or $80,000. And the problem is that both guarantors had done the exact same thing. The guarantee contract said you are on the hook if the primary obliger does not pay because whether there's a modification or not. Think about that. So I said a few dollars worth of legal help would have fixed the problem, because if somebody had brought this to me, I would have said, absolutely not. You do not agree to be a guarantor for anything more than you have to be. And I said, in that case, they should have struck that clause and said, no matter what happens, if you want me to be a guarantor, I'm only a guarantor if I've agreed to the extension to the lease. If I haven't agreed to it in writing, I'm not responsible. And both guarantors would have been off the hook if they just made that one minor modification to the contract. So, it's kind of a sad commentary, but it's important that people keep in mind good business practice. And so this it gives me an opportunity, like I said, talk about a real case example that was right here in Houston. So you've got creditor-surety relationships. Remember that you're in a fiduciary relationship when you have a creditor-surety relationship. You have financial and fidelity obligations in those cases. Now, one of the most common problems that we have when someone's acting as a guarantor is a lack of notice. So another thing that I do with my clients is to say, if you want me to act as a guarantor, you have to give me notice as soon as the person defaults. So in other words, if they're making a payment on the first every month, if they don't make that payment by the 10th of the month, you call me or send me a message right then. You don't wait 2-3 months until you've accelerated the whole balance due. And this is what often happens. The creditor waits until there's a big dynamic problem, grabs and says, we now want all of the money, not just the current missing payment or two. And the guarantor's kind of between a rock and a hard place. By requiring notice, what the guarantor can do is go in and say, here is that first month's missing payment plus the late fee. Let me go check on my client, my guy, and find out why he's not making the payments. In the meantime, I'll make the payments individually. And that's going to be a smoother situation than having to come up with a big corpus of money all at one time. And now keep in mind, if the surety does have to step in and pay for the underlying debtor, they then have what's called a subrogation right. They have a right to go in and act as the original creditor and say, look, we just paid $10,000 for you, plus a late fee of $500. You need to give us that $10,500 because we've just made good to your landlord or the person that the creditor. We're in the soup for this much money. You now owe it to us instead of the others. Doesn't go away. Now, in a rather obvious statement, again, this first statement's just silly because it's so obvious. If the principal, meaning the debtor, doesn't default, the surety is never asked to pay anything, obviously. Now, one of the things we talked about, remember we talked about a holder in due course. A holder in due course is only subject to real defenses, not to all defenses. But and so the principal may have a list of defenses, so it depends on the creditor whether the creditor is a holder or a holder in due course. If the underlying debtor is released, generally speaking, that releases the surety. Now, we just talked about this extension of time for payment. This is parallel to the situation I talked about in the slide talking about the WRS case. So what I want you to think about there is that in those cases, usually just an extension of time to pay will not trigger a surety to get out of the deal, depending on how the deal is written in the first place. And again, with regard to other modifications, I would put a trigger in there that says you can't modify it that causes more an increase in liability unless you get the guarantor's direct permission to extend additional credit, etc. Now, in dealing with the principal, if the surety has to pay, the surety has to account for anything that they've paid. The surety has a right to reimbursement, of course, and generally speaking, co-sureties, the bank can collect, or the creditor can collect from any surety or the sureties jointly. Now, remember what we said a few minutes ago is that there's a misleading terminology here in that an artisan's lien is on movable property. A mechanic's lien is an improvement to buildings or other improvements. So this protects contractors, suppliers, and others. Good example of this is air conditioning is a necessity in Houston. It's fairly expensive to put a new air conditioner in. So when a new air conditioner is installed in a building, the air conditioning contractor automatically has a mechanic's lien against that building until they are paid. Yes, sir, Alfonso.
Yes, just wondering if you can clarify the difference between the mechanic lien and the artisan's lien, because
yes,
they sound quite similar.
They are. The difference is the artisan's lien is on movable personal property. Let me go back to that slide. Back here on slide 4, a security interest in personal property for one is performed services. So that would be the mechanic who does work on your car versus our current situation, which is a mechanic's lien, which is a lien for value, materials, and labor in the construction of buildings and other fixed improvements. Doesn't say fixed, but that's what we're talking about. But that's the contrast. So again, the problem is it's intuitively backwards because most of us think a mechanic's lien, well, obviously that's the mechanic's lien for doing work on your car, and it's not, it's the artisan's lien. Okay?
Okay, thank you.
All right, you're very welcome.
Question. So
Sure, go ahead, Vanessa.
and this might just sound a little silly, but the UCC and the mechanics lien, are those like pretty similar? Because I've seen it where I've seen either or. It's like a mechanics lien is the UCC.
Well, yeah, actually, that's a great question because it reflects a differential in the way terminology is used. Because the UCC does not apply to real estate. Uniform Commercial Code does not apply to real estate. So it will only apply to movable goods, and then that would be what we would call an artisan's lien legally, but may be referred to as a mechanic's lien under the Uniform Commercial Code. So sorry about the confusion on that. I can't fix that. I don't have much control over that one. But it's a very good question, Vanessa. And let's see, supplier failed to notify the general contractor its claim for mechanic's lien the property within the deadline provided by the statute. Now, this is a very important issue here in Texas. The Texas lien law was so sloppy that to give you an idea, if somebody was mad at somebody, they could just run down to the county lien records and file a lien against somebody just to get even with them, just to mess up their ownership of the property. And when they go to sell it, they'd find out, oh my gosh, this guy's got a lien against my house, and I'm going to have to work out something with him to get the thing done. And that's without any notice to the owner. That was without any opportunity to know about what's going on. So Texas, after many, many complaints about this, obviously potential for abuse, the Texas legislature acted, and I think it was around the year 2000. I don't recall the exact year, but what they said was, is if you're going to put a lien on a property in Texas, and again, we're talking about mechanics liens, you must do it with notice to the party that owns the property, to the debtor if the debtor's different than the party that owns the property, and you must file within a fairly short period of time. I think it's like 30 days. And I've actually been involved in cases, like I work with some air conditioning service companies, and they contacted me about a well-known restaurant chain that wasn't paying their bills. By the way, that well-known restaurant chain is now gone. So even though it was a well-known restaurant chain, I guess due to some poor management, they didn't make it. This is several years ago, not related to COVID. So what happened in that situation, folks, is that they contacted me and they said, hey, XYZ restaurant hasn't paid us, and we've done about $7,000 worth of air conditioning repair work. Now, again, because that was on a fixed building, that is going to be legally in this chapter what's called a mechanics lien, but they had not given notice, and the thing, it was 6 months old. So the sad fact of the life is it was too late for them to file a lien on the piece of real estate or on the building. So it was a shame, because the restaurant chain, like I said, went out of business. They might have been able to get some salvage value, some money back, if they had properly filed their mechanics lien on the property. But after the fact, there wasn't much we could do for them. But that's a good example of why you need to stay on top. And if you're in business, you need to know the legal situation that applies to your particular business. So we're talking general terms here, but for each industry, and remember, some of these things change from state to state. The local lien filing rules that I just talked about only apply in Texas. Texas is a huge state. Most of us are going to be working exclusively within Texas. But if you are working interstate, you need to know what the rules are in each state where you have something going on. So how do you get that judgment? Well, I'm working on that right now. I mentioned at Tuesday night's class that I am working on enforcing a judgment against somebody that owes me some money in another state. And so we're seeking a writ of execution. That state does permit wage garnishment. However, we don't know if the person that owes me the money actually has a job. And so unfortunately, once we get our writ of execution, there may not be much we can do about it. And then, of course, you can file a lawsuit against the person to say, show up in court and pay us our money. Attachment is when the lien actually is applied to a particular piece of property. And so this situation happens if someone has a judgment brought against them, and you can find some property that they own in the state, then you can go to the court and say, well, this person owes me money. I've perfected the judgment. I have found this piece of property over there that the person owns. I want to put a lien on that. That is called attachment.